Good morning, everybody. Hello. Welcome on behalf of King's Chambers to the first of a series of 16 webinar talks by members of the King's Chambers commercial team. For those of you who don't know me, who am I? Well, I've been a barrister for 33 years, nearly 34 years, at King's, which of course has premises in Manchester, Leeds and Birmingham. And since 2010, I've also been a member of Gatehouse Chambers, formerly Hardwick in London. I'm formerly a former head of the Business and Property Group at King's, and my practice mainly covers commercial and what I would call the commercial end of Chancery work. I also sit as a Deputy Judge of the High Court in the Chancery Division and in the London and regional circuit commercial courts. I also sit regularly as a mediator and on occasions as an arbitrator. The seminar, the first of the seminars, is entitled Preparing for Trial and Appeals. And rather unimaginatively, I concede, I've divided it into two parts. The first part is preparing for trial, and then I'll speak about appeals. I plan to spend about 30 to 35 minutes on the first topic, and then about 5 to 10 minutes on the second topic. That's not because the appeals part isn't important, but frankly, there is probably less to say in a seminar of this sort. The format, I'm going to pause occasionally to let people ask questions. There are two ways of asking questions, as you probably all know now. The best way is to do it in the Q&A, but sometimes people put it in the chat function. But I will wait until the end probably to answer the questions, but do please ask questions. And also, if there's anything that arises subsequently, then you can always email through King's Chamber. So, it's an internal King's seminar. By that, I mean that, of course, I'm speaking on behalf of King's Chambers, but the price of what I call complete candour from me on this subject is that you should, I suggest, decouple my remarks from any specific cases that you may know that I've been involved in, especially any comments I make about working with solicitors and or the role of solicitors. As I say, I'm coming up for my 34th year at the bar. I joined King's in June 1991, and I genuinely mean that this talk is informed by that 34 years experience and not, for example, any specific recent experience that I have. The talk itself is something of a reprisal of a series of talks I gave now probably over 10 years ago. It's a testament, I suggest, to the fact that it remains highly relevant to our daily practice. Although we know that the vast majority indeed, of commercial chancery cases settle along the way, it remains the case that the entire structure of the civil procedure rules is underpinned by the essential assumption that the parties will end up in some form of trial. It can be seen more obviously in the relatively recent way in which costs budgets, for example, are prepared. Costs management in its current form has been with us since 2013, when it was introduced by the Civil Procedure Amendment Rules 2013, and the requirement in CPR Part 3.13, unless the court otherwise orders, for the parties to file and exchange budgets in the form of precedent H. That's the practice direction at 3D at paragraph 4A. Precedent H envisages a series of separate phases that the language we've all come to use for, and I remind everybody, although I'm sure they're all well known to everybody on this call, pre-action, issues/statements of case, CMC, disclosure, witness statements, expert reports, PTR, and then importantly for today's talk, separate phases of trial preparation and trial, and only then for ADR settlement. The entire budgeting process reflects each of the steps which the parties conventionally take towards the ultimate goal of trial. I've spoken in the past a lot in open forums and in a series of talks I gave to individual solicitors firms in Manchester and in Leeds on whether the trial process is fit for the 21st century. It was promoted in part by some judicial and extrajudicial comments on that topic, an interest which was prompted in my case by an illuminating talk that Mr. Justice Zaffaroli, as he then was, probably know that he is now in the Court of Appeal as of this month. It was an illuminating talk given by him to the Chancery Bar Association in January 2019, entitled, "Is the Trial Process in the Business and Property Courts fit for purpose in the 21st century?" I'm also very mindful of significant judicial and extrajudicial comment on the reliability of witness testimony, which for so long has underpinned our trial systems. In commercial cases involving commercial parties, there's been something of a sea change, I suggest, in approach. I said this in a recent case in which I was sitting as a judge in the London Circuit Commercial Court, a case called Aston Martin Lagonda Limited against Premier International Motors Group. Quote, "This is a commercial case involving commercial parties who, notwithstanding their connections, were dealing at commercial arm's length. When assessing their evidence, I was rightly reminded by Mr. Chapman, King's Counsel, of the proper approach to evidence based on recollection in this type of case, in the well-known decision of Mr. Justice Leggett, as he then was, in Guestman against Credit Suisse, especially his observations at paragraphs 15 to 22 as to the fallibility of human memory and reconstruction, and as to the effect which civil litigation has on memory. At paragraph 22, he cautioned, and I bear firmly in mind in this case, because I'm dealing with events that largely took place 7 or 8 years ago. In the light of these considerations, the best approach for a judge to adopt in the trial of a commercial case is, in my view, to place little, if any, reliance at all on witnesses' recollections of what was said in meetings and conversations, and to base factual findings on inferences drawn from the documentary evidence and known or probable facts. This does not mean that oral testimony serves no useful purpose, though its utility is often disproportionate to its length. But its value lies largely, as I see it, in the opportunity which cross-examination affords to subject the documentary record to critical scrutiny and to gauge the personality, motivations and working practices of a witness, rather than in testimony of what the witness records of particular conversations and events. Above all, it's important to avoid the fallacy of supposing that because a witness has confidence in his or her recollection and is honest, evidence based on that recollection provides any reliable guide to the truth. Guestman was revisited by Mr. Justice Leggett in Geoffrey Ross Blue and Michael James Wallace Ashley in paragraphs 65 to 69, in particular at 69 in the footnote where the judge added, in addition to the points that I noted in the Guestman case, 2 other findings of psychological research seem to me of assistance in the present case. First, numerous experiments have shown that when new information is encoded, which is related to the self, subsequent memory for that information is improved compared with the encoding of other information. Second, there's a powerful tendency for people to remember past events concerning themselves in a self-enhancing light. End of quote, end of long quote. The point I make is that, of course, the landscape of the work that we do in the business and property courts has changed significantly as a result of concerns over the reliability of witness testimony. There have also, of course, been recent significant reforms on disclosure. I have to always confess in these circumstances that I was involved in the working party which led to the reforms, and also, of course, reforms on witness statements. CPR Part 57A and Practice Direction 57AC, which impact upon this. But that, of course, is not this talk. So my remarks are predicated on the assumption that the trial is proceeding, much as it has for centuries. Although I would add that as far as I'm able to see, those wider considerations are still very much part of the agenda for discussion. Turning then to preparing for trial. Let's assume for these purposes a fairly typical 5 to 10 day trial. That in itself illustrates another way in which the talk I gave many years ago now has to be adapted, because in the business and property courts, we have the option of two other schemes provided by the Practice Direction 57AB in the shorter trials, the shorter trials scheme for cases of no more than 4 days, including reading, and the flexible trial scheme, which enables parties by agreement to adapt the trial procedure to suit their particular case, and is designed to encourage parties to limit disclosure and to confine oral evidence at trial to the minimum necessary for the fair resolution of the dispute, so as to reduce costs, reduce the time required for trial, and to enable them to obtain an earlier trial date. Anecdotally, at least, the take-up of both schemes has been somewhat slow, and for my part, I have not been involved in one. Much of what I say in this talk, however, will no doubt still apply to those type of schemes. But the main focus of this talk is on what I'm going to say is a conventional short to medium length trial proceeding in what I will describe as the usual way. There is, of course, fundamentally in the run-up to a trial, a huge difference in the roles played by solicitors and barristers. This is not a talk about trial advocacy, but about the nuts and bolts of preparing for trial. And I make no apology for that, because the fact that I'm just seeing the fact that there are 228 people on the call already suggests that there is some interest in this topic, albeit it perhaps is at the drier end of the options. Interestingly, the assumptions which underpin precedent H for budget purposes give us some clues as to what is meant by the phase of trial preparation. So see, for example, the table at Practice Direction 3D at paragraph 10. The trial preparation is assumed to include the following: preparation of trial bundles, witness summonses and arranging for witnesses to attend trial, including any final factual investigations, such as supplemental disclosure and witness statements, counsel's brief fee, agreeing with the brief fee, pre-trial conferences and advice from counsel, and pre-trial liaison with witnesses. Interestingly, I noted, having never looked, I think, at that table before, assembling and or copying the trial bundle is excluded, but only because that is not regarded as fee earner's work. The budget assumptions speak, I suggest, to three key aspects of trial preparation. Firstly, the preparation of trial bundles. Secondly, the handling of witnesses. And thirdly, liaison between solicitors and counsel. When I refer to trial bundles, I do, of course, acknowledge another significant change in the landscape as a result of the increased use of electronic bundles, both at trial and indeed in other hearings. Moreover, the preparation of electronic bundles poses different challenges and difficulties. Unless you're fortunate enough to have a fully managed trial with real-time action, and support from the likes of Opus and X-Bundle, all of the considerations I identify still have to be addressed. So, to the first of the three topics, trial bundles. It's my strong belief that it is only possible to understand how properly to prepare bundles for a trial by attending a trial. It's stating the obvious, but you would be surprised how many solicitors, especially junior ones, have not seen a trial, either at all or one of any length. That is a legacy of the fact that I've already mentioned that so many cases settle. It's particularly likely to be true of junior fee earners. And yet, as we will see, there is a tendency to delegate this type of task down, or even, as the budget assumptions hint, to persons other than fee earners. But if you do attend the trial, I suggest, or the next trial that you go to, or the last trial you attended, ask yourself the following questions. How did the advocate use the following documents? How did they use the skeleton argument? How did they use the trial bundles? How did they use any core bundle? How did they use the witness statements or evidence of expert reports in chief and in cross-examination of the witnesses of the other side. Ask yourself this: what problems arose for the court and advocates in using the bundles? What problems arose for the witnesses in using the bundle? Most problems, I suggest, can be avoided by a proper understanding of the answers to those questions, and crucially, a realistic and balanced approach to the issues of timing. There are two specific themes to this. There are issues of timing and issues of ownership. It's also important to note that the preparation of trial bundles is different from the more routine bundle preparation for procedural and interim hearings. First, as to timing, I confess, those who've worked with me will testify to this, that I am famously anal, forgive the expression, about the delivery of my trial bundles. Once I receive them, I cleave to them like a child connected by an umbilical cord. I cherish them. I don't let them out of my sight. There's a good reason for this, which I refer to below as part of the inverse curve. I'll return to that. The fact is, preparation of trial bundles, whether in hard copy or electronic, is boring, cumbersome, extremely time-consuming, and has to be done speedily and efficiently. However, it is a vitally important task if the trial is to run smoothly, and you, if your counsel and your solicitors, are not to incur the wrath of the judge. Frankly, your poor preparation of trial bundles should never feature in dispatches. There's a good reason for this. There is nothing worse than the start of a trial being dominated by complaints or practical issues with the bundles. Bear in mind that your clients, indeed everybody in the team, I suggest, is at a heightened sense of anxiety. And the client in particular is entitled to expect that this sort of stuff goes smoothly and without any adverse comment from the judge. However much you know, and we know, that the ultimate outcome will not be affected by this sort of stuff, clients are often fearful that it does. Bearing in mind that the entire exercise is being funded by them, or at least one side, it pays to get the preparation right. Moreover, as we will see, there's now no real excuse for not getting it right, when proper regard is now had to the guidance given in things like the Chancery Guide, the King's Bench Guide, the Commercial and Admiralty Court Guide, and the like, and the similar, of course, for TCC. There is extensive guidance in each of those sources. So, in the Chancery Guide, the whole of Chapter 12 is devoted to trials under Part 7 or Part 8. Section 1A of the Civil Procedure, including specific paragraphs dealing with IT, documents for trial, and a specific Appendix X on the preparation of bundles, which itself runs to 21 paragraphs. The King's Bench Guide, similarly, entirety of Chapter 14, is devoted to trial judgments and orders, including 11 paragraphs on electronic and hard copy bundles. In the Commercial Court, the entirety of Section J and at J 4.1, provision for bundles to be prepared in accordance with Appendix 7. Now, while the guides are really good at setting out what should happen, they are less good at explaining why the guidance is in place. And in any event, in my long experience, they are rarely adhered to in practice. Of course, they are in the nature of guidance, and there's often good reason to depart from them. But as a default or starting position, they are often simply overlooked. Cue an awkward conversation on bundles, where I ask someone if they have looked at what the relevant guide said. As to why the rules are in place, I will touch on some of that in the course of this talk. The first rule on bundles is it's almost always going to take longer than anticipated. It's vital, I suggest, that counsel is genuinely and proactively involved at the CCMC and PTR stages, The Chancery Guide reminds us that preparation should be begun in sufficient time to enable the bundles to be agreed with the other side, and references to bundles to be used in skeleton argument, and for the bundles to be delivered to court in time. Excuse me. Generally, I suggest that means the claimant should be submitting proposals to the other parties at least 6 weeks before the date of trial, to allow at least 4 weeks to agree the index and content. And I suggest at least 2 weeks for collating documents and 2 weeks for copying distribution. The default position is 10 days prior to the date for submitting skeleton argument. But that 10 days is almost certainly going to be inadequate because it just simply doesn't provide sufficient prep time for everybody. So bear in mind, these are guidance, but in almost all of the cases, I have to say, and always the first set of directions that is produced, say, at the CCMC, does not allow sufficient time for all of that to happen. If you want a rule of thumb, I suggest, take the period which your opponent's solicitors provided the draft direct and double it. I mentioned something about ownership. Whose responsibility is it to prepare the trial bundles? Too often, I've hinted, it's delegated to someone who's junior and who's not had any experience of trial. Of course, costs, budgets, and costs generally require that we properly delegate, but a degree of supervision still has to be assumed by senior members of the team. Most importantly, are tactical considerations at play here. How cooperative are the other side going to be? I find it amazing that in some of the most aggressively fought litigation, the assumption somehow is that both parties will cooperate on the bundles, when they've so far not been able to agree that night is night and day is day. It's especially a consideration if your side are not the team preparing the bundles. So, for example, typically, if I'm acting for a defendant, I always advise that you should anticipate that the claimant may not cooperate in the way that they will. Think about it. Of course, it's tactically, it's a tactical consideration because it enables the claimant, for example, to ensure that their side have the bundles before the defendants do. Don't be ready, to apply to court quickly if there's no cooperation. Again, it seems trivial to go back to court on the issue of trial bundles, but bearing in mind they're important and the importance of the preparation time that I've already identified, it's absolutely vital that you behave, that you react if the other side are not playing ball. Don't underestimate and allow, if possible, for delays in clients agreeing brief fees. One of the most common reasons, I have to say, why there is a delay in ever preparing the bundles is for that reason. The conversations about brief fees often happen too late, whereas in my judgment, they should happen much earlier so that nobody is shocked and it doesn't delay the process. Factor in, of course, there's likely to be a need for a pre-trial conference, and if so, when can it take place? It frankly makes no sense to have a pre-trial conference with, say, experts if the bundles are not almost fully prepared, because it's highly likely in the sort of work that we do that we will be referring to documents within the bundles when we want to talk to the experts, and indeed the same can be said of lay witnesses. Is there time, therefore, for the bundles to be used effectively at meetings with clients, witnesses, experts? And then there's this question: how long do the advocate really need? Too often, the time for their preparation is squeezed by solicitors taking more of the available time. I know it's difficult for everybody, but quite frankly, some of the most difficult, and I mean really, really difficult conversations I have had with solicitors around them stealing my preparation time because they have not done their bit, because or they've left it too late, or because they've taken a passive rather than proactive stance if the other side are not cooperating. Even worse, sometimes, of course, they ask for extensions of time to cover their default. Now, I want to say something more controversial about ownership. And I'm not here just talking about bundles, but about ownership of the case. I'll introduce you, I said, to what I call the inverse curve. The inverse curve is the enthusiastic partner in charge who you saw in the first car, but who by the time you approach trial has largely vanished. His or her involvement is in inverse proportion to the proximity to trial. As the trial approaches, you will see or hear less from him or her because he or she is deferred to more junior colleagues. Now, of course, there are good reasons for it. A saving of costs, but there can also be issues of ownership. What do I mean by ownership? Well, everybody, especially sometimes the solicitor, is getting nervous about the case and indeed might even be getting grief from the client, or the client is giving solicitor grief over, for example, case or agreeing fees. But do beware of what I call inappropriate delegation. At the same time, the client is maybe losing confidence in the case, confidence in the solicitors, possibly even the entire team, including counsel, or is not losing confidence in the case, at the very least having anxieties about the case. And self-evidently, the person who takes up the slack at this point is likely to be the trial advocate. The typical position up to that point has been that counsel's involvement is fairly sporadic rather than constant, matching the typical six-phase progress towards trial. Excuse me. You recall the pleading phase is where counsel is often heavily involved. The disclosure phase, perhaps to a lesser extent nowadays, certainly the witness evidence phase, and certainly the expert evidence phase, and also the ADR phase. But of course, self-evidently, it's reflected in the typical cost budget that where the proportion of solicitors' costs to disbursements on counsel is generally much higher during those phases, but entirely reversed when we get to the trial preparation and trial phases. I like to think of it as being the loneliness of the long-distance runner. Don't get me wrong, one of the most rewarding aspects of our job is to take on that leadership role. It's what we're trained for, and it's why we're paid so much for our job. And of course, it is also mitigated, the inverse curve is also mitigated by that. It often means that we are working with highly competent, self-motivated, sympathetic, empathetic, and enthusiastic juniors. And I genuinely mean that. But there is a balance to be struck, is the point of this. When preparing for a trial, we do still need the senior people to be involved. The timing, though, and ownership points coalesce in a period of maximum stress and exactly the time when maximum effort and maximum responsibility in counsel occurs. I have to say, many lay clients and even some professional ones have simply no idea what that means in real terms. A boring word on the format of bundles is this: it's almost all in the guidance. In the case of the Chancery Division, in Appendix X, the rules make sense. They've been worked out between specialist bar associations and solicitors and the judges. As to content, of course, of the trial bundles, and here, of course, I do acknowledge that electronic are different, but there are some obvious points to be made. So, for example, albeit in the context of talking about the core bundle, the Chancery guidance says this, and you might wonder why we should have to say it. So paragraph 6, unless the court directs otherwise, the core bundle should be filed as an electronic bundle and in hard copy. The hard copy and electronic versions must be identical. The very fact that the guidance has to say that the electronic and hard copy bundles should be identical is an indication that has not always been the case. But the obvious things about bundles are don't overfill them. Don't overfill physical bundles. Don't, I suggest, fall out with the other side over the inclusion of specific documents. In my experience, too much time is spent on this when it's almost always capable of being resolved by having, for example, a separate bundle of non-agreed documents. One specific warning, don't overlook the consequence of agreeing bundles. There's an often overlooked provision in CPR Practice Direction at 32 at paragraph 27.2, which provides that documents in bundles which have been agreed for use at a hearing are admissible as evidence of their content, unless the court otherwise orders or a party gives written notice of objection to the admissibility of particular documents. So if the authenticity of one or more documents is an issue, or is likely to be so, consider at a very early stage whether asking the court to make a direction to exclude the effect of that rule. As to the format of the bundles, well, again, the guidance tells us really the answer. Don't duplicate documents unless there's reason to do so, and omit things like back sheets. Be aware some documents which, for example, have several manuscript amendments on it, because that means that they are effectively different documents. We're just going back to that duplication point. Although now increasingly we are preparing electronic bundles and using electronic bundles, that shouldn't be an excuse for just putting everything in. But again, I'm afraid my recent experience suggests that there is a tendency now to just do that because it's easier to include everything than to take out those that are irrelevant. Even in the electronic context and using electronic bundles, it is still important to discriminate as to what should go in and what shouldn't go in. And the fact that the judge, for example, will only be referred to specific documents doesn't mean that shouldn't still happen. Note in the guidance, the general rule is as to the primacy of what's called the chronological or contemporaneous bundle. This means all documents should be in chronological order, not separate bundles or tabs for each party's disclosure. Parties will be penalised in the modern regime for excessive or unnecessary copying, and the process of agreeing bundles includes removing things which are not relevant. Again, if the other side refused to cooperate, consider an early application to court, or at the very least, letters warning of the consequences if the over-inclusion of material is going to ultimately be criticised. Sometimes themed is better, but in my experience, not often. By that I mean a departure from the general principle that things should be chronological as opposed to thematic. Themed is sometimes appropriate, where, for example, the chronology is less likely to be of significance, and where, for example, there are discrete issues in the case, all of which generate a different series of documents, for example. In the electronic context, of course, bookmarking is especially important. The ability to navigate through the bundles becomes even more important, in my experience, if electronic bundles are being used. The Chancery Guide also, for example, correctly sets out that witness statements should only exhibit documents not otherwise available on disclosure, and that if documents are exhibited to witness statements, they shouldn't be included in trial bundles in that form. In other words, you take them out of the, for the purpose of trial, they cease to be exhibits to the statement and simply become part of the general chronological bundle. Failure to do that not only tends to cause unnecessary duplication, but it means often that the judges are working from different references for the same document, and the document is used in a witness statement may, of course, not be in logical order. Bundles should be named and paginated. Again, I could speak at great length about this, I'm afraid. Different practices, of course, prevail, but you'd be astonished how often this task is overcomplicated. In other words, in large cases, it's simply better to adopt internal numbering within separate bundles, themselves, for example, conventionally identified as A or 1 or A1, so as to avoid unwieldy and long page references. So, for example, the difficulty with numbering, say, 20 bundles from 1 to the end is that the references become unwieldy and they become more capable of error. The more if you've got 4 digits in a reference, there are 3 more opportunities to make a mistake. Lettering, of course, permits sub-bundles to be prepared, so you can have A1, A2, A3. Numbering, as I say, the whole set of bundles gives rise to references which are sometimes difficult to say and more difficult, for example, for witnesses to understand and create more opportunities for errors. Bear in mind that when cross-examining, there's often a desire to be punchy. And if, for example, the trial bundle references involve more than 3 digits, that, of course, impacts upon the way in which you can ask the question. I do think there is a tendency to overcomplicate this. I've had many different complications. It is helpful, for example, to have, say, all the expert reports within the same generic lettering, say 3 bundles marked E1, 2, 3. But frankly, that is less important than just ensuring that the bundles run smoothly. And sometimes it really is just better to number the bundles 1 to 30 or 1 to 50, whatever it is. Having both letters and numbers is, however, not particularly helpful. It's almost always going to be necessary to supplement the trial bundles. And if so, the person who's seeking to do that must circulate paginated and hole-punched copies, or in the electronic format, a letter explaining what has changed. Too often, in my experience in the run-up to trial, with no necessarily sinister intent, it's just unfortunate when everybody's very busy. But too often, documents get added into the bundle without anybody actually realising they've been added in. And if, like me, I have a particular way of preparing for trial myself, and of course it's important to know if documents have gone in, not least because the fact that they are a late inclusion generally means that somebody regards them as being fairly important. So do you have some sort of convention in place, whether it's electronic or hard copies? It's important. The general practice is to adopt some sort of lettering. So, for example, if it's page 100, to add something like A, B, to Z, Z, Z. But the important thing is to establish a convention for both sides to stick to. Again, I'm afraid have had fallouts between solicitors as to whether documents should even be added into the bundle. Again, bear in mind the stress level that we are all at in the run-up to trial, that is not especially helpful. Remember also, documents in manuscript or with manuscript markings generally should be transcribed according to the rules, and foreign documents translated. The witness statements, of course, should generally be cross-referenced, not now to the exhibit, but to the trial bundles themselves. And again, that's something that, in my experience, often happens too late. It is incredibly helpful, both as a judge, I can say, and also as a barrister, an advocate at trial, to be able to have those references when you are preparing, because it saves a huge amount of time. So there is a reason for it. So the cross-referencing to the trial bundles is so that everybody, when reading the relevant passage in the witness statement, can cross-refer to the documents that is being referred to. Documents, again, and this is often overlooked, should be marked to indicate the party from whose disclosure they've been sourced. The Chancery Guide deals with that in Appendix X at paragraph 14. But I have to say, in my experience, it almost never happens. But again, what is often overlooked is the fact that at trial, issues will sometimes arise as to the provenance of the document. And whilst it's my general practice to advise that, for example, lists should go into one of the trial bundles so that that reference can be made, it is far quicker if the Chancery Guide is followed and those cross-references are already there. Save in cases with few documents, also the almost unheard of in our world, I have to say. And it is at trial, it's likely that there will need to be reference to more than one bundle at the same time. That's the reason why the Chancery Guide and the other guides, for example, say that the bundles should be marked on the inner top right-hand corner. That's, again, it makes perfect sense to us because we understand why that's the case. It's not obvious, for example, to a junior solicitor in the team why they would do it. And I have to say, I'm afraid it often doesn't happen. But there's a very good reason for it, because at any one point, if I'm cross-examining, I may have several bundles open at once. And generally speaking, again, I don't suggest this is written in stone, but the following format seems to work. Bundle A, pleadings, orders, lists of documents. Contrary to the Chancery Guide, the chapter form is rarely used in this, and it's usual to include, for example, previous versions or amended pleadings. Again, often overlooked, but you may very well want to demonstrate in the course of cross-examination how a party or a witness has changed their case. Bundle B, generally speaking, witness statements or witnesses' fact. Bundle C, reports of expert witnesses. And then Bundle D, all of the chronological documents running, no doubt, to several bundles. It is often useful to have relevant interim applications in their witness statement. And then finally, any relevant inter-parties correspondence. But again, in the Chancery Guide warns, that really should be limited to anything that is likely to be needed. I wanted to say a word about core bundles. In a large case where there are a lot of documents which will be referred to frequently, then a core bundle does help. But again, there's often a misunderstanding about core bundle. It's just that it's a bundle that contains documents that are likely to be referred to frequently. So the obvious example, if the case concerns the construction or enforcement of a contract, it's generally helpful for everybody to have a separate bundle with that contract in there. What it isn't is a bundle containing, for example, the pleadings. In other words, by core, it's a reference to core documents likely to be referred to. Indices are a vital tool in navigating a trial bundle, and again, even more so, I suggested, electronic format. Practices differ, but many advocates rely heavily on the index for preparation and in the course of cross-examination. I will suggest that when preparing indices, prepare for the worst. Imagine that if your advocate loses their notes, then they ought to be able to find relatively quickly by reference to the index what they're looking for. I've already said something about the labelling of bundles. I've talked about the labelling inside the bundle on the inside corner, but the labels appearing on the front spine and on wherever they appear, they have to be large and bold, and in large cases identify whose bundle it is. They don't need to identify, for example, solicitors' names, addresses, and the like. They are functional tools, and they're not marketing tools. And again, I get bundles where they have labels with neatly written out versions of the case, everything but what I need, which is the letter A, for example, on the spine in large ink. It's not just about me, I should say. This isn't just about advocates. It's not even just about the judges. It's also about witnesses. That is pretty lonely in the witness box. And if the witnesses struggle, for example, to be able to see which bundle they're being referred to, it makes it very uncomfortable for them. So make it easy for them. Just a word about the trial toolkit. This is a literal, not a metaphorical toolkit. Aside from the most usual virtual or real pens and post-its, notebooks, staplers, in my case, my trial toolkit almost always includes things like pliers and things to be able to open bundles when but again, electronic bundles help in relation to that. I'm going to stop talking about trial preparation, you'll be relieved to know, and talk about that, or that aspect. I'm going to stop talking about bundles and say something about the management of witnesses. Now, I'm not here talking about the nuts and bolts of how to cross-examine, but effective trial preparation means preparing the client and witnesses well in advance. I am not, of course, talking about coaching, which is impermissible. But I'm astonished by the number of clients and witnesses who don't really understand what is going to happen at trial, in the sense both of the process and their part in it. It's my practice to have a meeting with clients and witnesses to explain that, but not everybody does that. But they often misunderstand the entire meaning and role of evidence, for example. A warning sign is the witness who laments, for example, that they have no proof of something, when what they actually mean is that they lack proof in the form of a document. It's out with this session to talk about those reforms to witness statements, save to emphasise that most of it isn't new, and it should help, not hinder, the preparation of effective witness statements. It's a reminder that the purpose is for a witness to give the evidence in chief, which he would be permitted to give orally, on matters of fact of which the witness has personal knowledge, and if practicable, in his own language. One of the understated problems with the criticism of witness statements which don't comply is that the witness may go into the witness box completely unprepared for the onslaught of criticism which he or she may face as a result of non-compliance. At best, that's unsettling. At worst, it's fatally damaging to the substantive weight and credit of the witness. But prepare the witnesses for that process. For example, talk to them about the management of their adrenaline, of everybody's adrenaline, the entire team. Prepare them for the fact that they're going to have to manage their energy, prepare everybody for that. They're going to have to manage fatigue in parts of the case. There's never an instance where they're likely to become bored in a case, but you do have to manage fatigue. And in particular, talk to them about trial etiquette. So, for example, help witnesses and clients to understand the highly charged atmosphere of court. Help them to know what to take or what not to take into court. So, for example, it's helpful to tell them that they can't take coffee cups in, for example. They can't go take a Starbucks sandwich. Help them to understand the professional constraints and obligations that you're under. So, for example, it's far easier to handle the late production of a document if you've explained it to them, if you've explained its likely impact and effect, if explained it neutrally and in advance. Help them, for example, to know where to stand, when to bow, when to rise and when to sit, and why other people will be bowing. Explain to them how to address the court and how to deal with, for example, your opponents at court. All of this, again, tends just not to happen in my experience. Help them to know when to leave court and how. So, for example, the obvious one, people often don't realise that they can leave the court during a session if they need, for example, to go to the loo. And help them to understand what the role of the court staff will play. One from me, in my capacity as a judge, you really do hear the sotto voce remarks and grimaces, and you see the grimaces. It's extraordinary how much you can pick up when you are sitting on the bench. And again, in my experience, it's better to explain to clients that they and witnesses that they shouldn't do that. So effective trial preparation means preparing the clients, as I say, falling short of coaching. I have a view about witness training programs. They can be effective, but in my experience, it's often obvious that witnesses have been trained, and that's not necessarily desirable. What I usually say is that if you've got an exceptionally, and I mean really exceptionally nervous witness, then it may help to undergo witness training. However, even if you don't have them trained, there's an obvious thing that you can do, which is take them to court so they can sit at the back and actually just watch some proceedings. That often helps to comfort them or relax them. So visiting the court is important. So I've talked about trial preparation in the sense of bundles, and I've talked about the preparation of witnesses and clients for the trial. The final thing I wanted to say something about before I deal briefly with appeals is the relationship between solicitors and counsel. The effective trial preparation obviously means briefing the advocate. Hopefully, that will mean briefing them with bundles which open and close without reference to the toolbox, bundles which arrive with a realistic time to prepare. And remember, there is, of course, the opportunity to talk to us and our clerks about staged briefs rather than brief late because of, for example, late settlement negotiations. Hopefully, effective briefing of the counsel means numbered and identified boxes, identified bundles arriving in boxes, a separate bundle, of course, containing privileged material and or without prejudice offers and matters relevant to costs, and notes contained on the witness evidence or the expert report. Hopefully, there'll be time for a pre-trial conference. And finally, something that has really fallen out of favour is a brief with your thoughts on the case and the trial. Again, so often I'm afraid that doesn't happen. One of the best things about working in a team is if everybody contributes. And so often the full brief simply doesn't happen. Hopefully, it's been delivered with a realistic time for preparation of the skeleton argument, and therefore without the solicitors having agreed a deadline for submission, which bears no relation to the timescale for delivery of the bundle. I've already mentioned that I then regard it as part of my job to explain the trial process to clients and witnesses and experts. I tend to go through what each day will look like and what they can expect to see to do. But I think at this stage, it's also helpful to explain briefly costs and appeal processes. Something that is very important at this point is to explain to the client the fact that it's likely that a draft judgment will be circulated in advance and that it will be embargoed. In other words, it will be confidential. And bearing in mind the consequences of ignoring that, it's really important, it seems to me, that is reinforced at all stages. Think also about, for example, this has occurred in a case that I've done recently, where it might be necessary to ask the judge for permission to share the draft judgment with people other than the parties. Say, for example, if you have costs funders involved in the case, where they wouldn't normally be, you wouldn't normally be able to talk to them about the case until judgment was formally handed down. All right, I'm conscious of time. I have gone on slightly longer than I said I would on trial preparation. Turning to appeals. Okay, so the decision has gone the wrong way for your client. It's not the purpose of this talk to set out the procedural steps, the appeal in detail. You'll find all of that, of course, in the civil procedure rules. But I will comment on certain rules or parts of the practice direction. I want to focus on certain procedural hurdles and points of practice. The first point to make is the point I've just made, which is that the explaining about appeals should be part of the preparation for trial. It's better for them to understand the appeal structure at that point when it's neutral than having to do it for the first time after the judgment has been handed down in draft. A permission against an appeal, generally, of course, you will ask for permission from the trial judge, but of course it's not fatal because you can repeat the request in to the court, to say the Court of Appeal. The test for permission on first appeals is that the appeal must have a real prospect of success, or there's some other compelling reason for the appeal to be heard. That's CPR 52.61. For second appeal, it's that the appeal must have a real prospect of success and raise an important point of principle or practice. That's CPR 52.7, subparagraph 2. Timing, of course, is crucial. Unless the lower court orders otherwise, the appellant's notice is to be filed within 21 days. And that's a really short period of time, especially when, in practice, you are having to manage a lot of things at this point. In practice, it means that preparation of the any appellant's notice has to begin either during the period of the embargoed draft judgment or in the week immediately after it's handed down. I say that because too often, for understandable reasons, the client simply wants to think about the prospect of an appeal when in reality, the timescales are so tight that there isn't really a great luxury of thought. So during the embargoed period, of course, there are serious practical considerations. First of all, your client may be in shock. They may need to consult others. So, for example, family, advisors, funders, when there's a strict embargo on circulating the judgment or revealing its content. If you anticipate difficulties, then, as I say, it's helpful to ask a judge for specific permissions to lift the embargo. At that early stage, there's also the practical difficulty that it's not always the case that transcripts are available. I haven't said anything about trial transcripts, but because practices differ, where they are available, where there have been daily transcripts, then obviously that also makes it easier at this stage. But it's where there are that it can be particularly difficult. Drafting grounds is very difficult for everybody because it requires a complete shift of mindset from the trial, both as to understanding and reappraising the merits, and also because the process is always the opposite of the focus at trial. Unlike the multifactorial focus of a trial that I've already been talking about, the focus of an appeal is generally laser beam. There's a tendency to be over-inclusive in drafting grounds of appeal, but that can be, I suggest, counterproductive. Although it is, of course, open to the judge granting permission to grant permission on only one of several grounds. The CPR-PD 52C, which is concerned with appeals to the Court of Appeal, provides, for example, paragraph 5.51, that the grounds of appeal must identify as concisely as possible the respects in which the judgment of the court below is either A, wrong, or B, unjust, because of a serious procedural or other irregularity. In my experience, it's difficult sometimes for clients to grasp the distinction between an appeal, which is against the order the judge made, and not necessarily the reasons for the decision, many, of course, which relate to findings of fact on peripheral issues. In the case of second appeals, the grounds of appeal, of course, have to identify the important point of principle or practice or compelling reason which justifies permission. Inevitably, those cases are likely to be very rare. But again, it's often difficult for clients to grasp just exactly what that means. The important point of principle or practice, especially because, of course, to them, the case is of vital importance. But understanding exactly that meaning, understanding exactly what that means for the purpose of an appeal is genuinely difficult. It's often overlooked that the practice direction to Part 52C provides at paragraph 21 for the parties to review the case with a view to resolution or refinement of the issues to be determined at an appeal. The timing of this is said to be promptly after permission to appeal is granted. This will generally be before the respondent's notice has been filed and is perhaps unrealistic when given the raw emotions of the situation. Finally, in relation to the timing of appeals, everybody needs to be prepared for a long haul in some instances. Although the listing in the Court of Appeal is now significantly better, given the redirection of many civil appeals to be heard by the High Court, there is still likely to be a significant delay, and also be conscious of the fact that the Court of Appeal still sometimes lists the permission application with the appeal to follow, which is possibly the worst of all worlds in relation to costs and managing client expectations. Thank you very much. That brings me to the end of my talk. I see there are two questions in the Q&A, which I will, I hope, be able to deal with. Josh Coleman has asked about my view on witness familiarisation. I think I've already hinted at this, and I've seen it both in my capacity as a barrister and also as a judge. There are obviously very good programmes out there. The concern I have about it is that too often it is obvious that the person has been trained, and I think that that's a fault of the training. I think I mentioned in the course of the main body of my talk that I would suggest it's appropriate only for the sort of witness, and I would suggest they should be fairly rare, who is genuinely extremely nervous about giving evidence on the process. But I also mentioned a possible alternative of taking them along to court, which I think should happen routinely anyway. But it's perhaps right to say that I am not, therefore, a fan of routine witness familiarisation. It seems to me that the proper role, a combination of a visit to court to understand the process and the geography of a trial of a case, combined with the proper explanation that I've suggested should be given by solicitors and by counsel, should be sufficient. The second question is from somebody anonymous saying, what if the other side have not complied with the order for exchange of evidence? Right, there's two aspects to the question that I'm being asked. So the answer to the first bit, namely if there's not been compliance with an order for exchange of evidence, is that you should apply to court for an unless order. In other words, to apply, and that sort of application can generally be heard pretty quickly, particularly if you're in the run-up to trial. The second part of the question is about what the questioner says is that they have no confidence that the other side will prepare the bundle or do it properly. And again, I think I've touched upon that. If just go back to court is the short answer, whilst it seems unfortunate that parties should have to make applications in that situation. Frankly, if you've exhausted everything else and or you genuinely think they're not going to be able to do the job properly, there is a third possibility, which is to do it yourself. But obviously, if you were to do that, I would suggest it should be prefaced with the sort of correspondence warning that you'll seek the costs of doing it from the other side. Could I, first of all, thank you all for listening. I hope it's been useful to you. And of course, as I mentioned earlier, if anybody does think of any further questions, then do by all means direct it to me, either directly or through the marketing. I mentioned at the beginning, this is the first of a series of 16 talks. I do hope that a lot of you will be able to join us on the journey towards number 16.